Hello, everybody. Good evening. Welcome back to another episode of Wednesday Night Live, brought to you by Courtroom Confidential, the fastest growing true crime channel on YouTube. Tiffany tells me, I don't know if you can say that. I don't know if that's true. And I say, well, we don't know it's not true. And that's the lawyer in me saying, go ahead and prove me wrong. Thank you all so much for taking the time out of your Wednesday night to come join me and talk about some news in the true crime world. And tonight's going to be a fun one. I think we have a lot of interesting stuff to get into. First of all, we are going to talk about Sarah Boone testifying. I know that was the big news for the week. She finally did take the stand. It was interesting, and I didn't want to do an entire review of her entire testimony, but we're going to pick what I think are the highlights, what I actually think is the turning point in her trial, if there is a turning point. First of all, hello to all of the familiar names, Robin and Afton and Creative Minds and Ashley and Aunt Nancy. Good evening to you all. I see you in the chat. Thank you so much for joining us. So we'll talk about Sarah Boone, get into her testimony, get into the ruling that is a pivotal ruling in this entire case. If Sarah Boone has any chance, it happened because of this ruling that took place. I think this entire trial, if we look back at the results of this trial, it will come back to this moment that we're going to talk about. And a little bit of the cross. But like I said, I tried to choose some highlights rather than going through the whole thing, because that would have just taken up all of our time. Then we're going to talk about Charlie Adelson. You know, he made that motion. We talked about that last week. Now the state has responded to it. I enjoyed their response. We'll get into that a little bit. And then I thought it would be fun. Would you guys like to watch somebody throw knives at a pig? Doesn't that just sound like loads of fun? We're going to get into that, and I'll explain how in the world, in a criminal courtroom, people sat around and seriously watched a full-grown man throwing knives at a pig carcass and what that had to do with anything. So, lots of fun things to get into. I want to thank some people that I didn't get a chance to thank last time. Someone criticized me in the chat a while ago and said, you take too much time thanking people. And I said, you know what? If people take the time out of their lives to go ahead and watch and to contribute and be a part of this community, well, then I'm going to take the few seconds it takes to go ahead and thank them. So Kat for gifting memberships, Donna for a super chat, Jen St. Peter and Afton Fored. All of you are fantastic for the contributions of memberships. Thank you. Thank you so much. Speaking of memberships, we have some new members. Tina, Lindsay Bay, Jenny Meow Meow, Meg P, Dizzy, Kathy Avery, Fern, Kim Delorme, Creative Minds, and Too Good For You, spelled as if it was a Prince song title. Too Good For You. Thank you guys all so much for being brand new members. Speaking of membership, if you guys are interested in all of the benefits, you can always check the link that will be in the notes of this episode, or just go onto the website and check out all of the benefits for membership. So there's everything I have to say. Hope I didn't take up too much of your time getting into all of that, but I think it's important stuff, and I appreciate you guys so much. Here's what we're going to do first with with Sarah Boone. She, if you remember, her attorney said in opening statements that a big thing about this trial, what they will learn that will change their minds about this entire trial, takes place in the 11 minutes between the first video that we've seen and the second video that we've seen. These are the videos that she recorded on her own phone of George Torres inside of that suitcase begging for his own life. She took one video They know by the timestamps 11 minutes passed, and then she took another video, and they're saying that the entire secret to this case can be unlocked by understanding what took place in those 11 minutes. This is the point in the testimony where she tells us what takes place in those 11 minutes. So we're going to get into that. But my first question before we even start down this path is, isn't it a little bizarre that this is the same person who testifies during this same testimony that she doesn't remember taking the videos, yet now she's saying she remembers what took place in those 11 minutes? That is something for argument. That is something that I hope the prosecution makes a big point of. To me, that's a glaring problem. But here's what she says during those 11 minutes. I want to take as many questions as you guys have. So if you put them into the comments, please make sure you put question marks or QQQ so that we know to flag them, and we will try to get to them as much as possible. Laura Waldy, thank you so much for the gifting the membership. All right, let's go ahead and get into this thing then.
So between the 2-minute video and the 22-second video is an 11-minute period. Could you tell the jury what happened?
We continued to, I guess, speak to one another, and his tone changed, and I knew the tone, and we ended up, I guess, arguing back and forth with one another, and it was the things that he was saying very much frightened me, and cursing at me and threatening me. And
Did he want you to let him out of the suitcase?
I'm sure so.
Go ahead, tell me.
And it got very heated very quickly, and he continued to push on the suitcase. And my fear was that he was going to break out of the suitcase, knowing that it was a broken suitcase. And his hand started to come through. His hand started to come through this way. And so I shook the suitcase. Trying to get his hand to go back in, shaking it, and telling him that, please stop doing this. Please stop doing this to me. Please stop doing this to me.
So his hand actually got out of the suitcase.
Yes.
And you went to the suitcase.
Yes.
And shook it.
Yes.
Did that force his hand to go back in?
No.
So you're shaking it. Were you shaking it to try to get the suitcase, his hand back in?
Yes.
How long did you shake it?
I don't know.
But his hand was still out.
Yes.
Was he trying to get out?
Forcefully, yes.
Was he angry at you?
Yes.
Okay, I got to pause for a moment here. First of all, I want to make sure you guys are hearing this all properly, because I'm always worried that you're not getting the sound. So let me know if it's bad quality sound. But secondly, this started to annoy me because are we honestly expected to start to feel bad for her because he was struggling to get out of the suitcase? I mean, he's saying, was he trying to get out? Yes, he was trying to get out. Were you shaking the suitcase to keep him inside? Yes, I was shaking it to keep him inside. I mean, just for a moment, pump the brakes and think about the ridiculousness of what we're listening to here, that we are supposed to somehow emotionally be in tune with, entwined with a person who is saying that she is the victim here in a situation where a man is trapped inside of a suitcase, desperately trying to get out to save his own life, and wasn't cooperating. Just going to drop that note in the middle of this whole thing and think about perhaps how is the jury viewing this?
Were you in fear? If he would have gotten out of the suitcase, what would he have done to you?
Like he used to tell me, he probably would have made me unrecognizable, or I would have lost my life.
Okay. So there really is the whole point of what their testimony was coming down to. What did you believe would have happened if he got out of the suitcase? He would have harmed me. He would have taken my life. I was afraid for my life if he got out of the suitcase. By the way, I know that we're not including all of this, but do you see how we went from playing games, painting, playing with the dogs, having some Chardonnay, listening to music and dancing. Now we're playing hide and go seek. He. What a fun evening. To all of a sudden, it's if I let this man out of the suitcase, he's going to end my life. And I'm not trying to belittle victims of abuse here. And if she truly is a victim of systematic violence, then you can understand this flip that might take place in her own mind. But it is remarkable to hear it play out in the way that she's described it, especially in the way that she's doing it with her demeanor. Her demeanor to me was also one of the most shocking things. This person's pulse didn't raise above someone simply describing their routine for the evening. I took out the trash. I filled up the washing machine. I folded some laundry. I locked my boyfriend in his suitcase while he begged to get out. Then I set my alarm for the next day, gave the dog a last minute treat. I mean, it was like it was never, none of this seemed to be a person reliving something so traumatic that, by the way, this man died who she's telling us she loved. Again, just going to drop that there.
Did you lose the grip on the suitcase?
Yes.
Where was the bat in relation to the suitcase?
It was maybe up against the dining room table right there.
How far was the bat from the suitcase?
3 feet, 2 feet.
Was his hand still out of the suitcase?
Yes.
And was he getting out of the suitcase?
He very much was trying, yes.
And so what did you do?
For the split second reaction that I had, I happened to see that and I grabbed the baseball bat and was trying to poke his hand to go back in to please don't break through, please. So I hit his hand.
What did you hit? The outside part of his hand.
Yes.
We've seen the photographs of his left hand. Did you cause the bruising there?
I'm guessing yes.
Now, you've seen the bat. A huge bat?
Yes, I bought it for my son.
Is this bat you used?
Yes.
And you said you poked him with it?
Yes, I kind of pushed, like I held it with the skinny part here and then
So grip here.
brought it at it, yes.
You grabbed it with both hands here,
Yes.
and then the barrel of the bat, the big part of the bat is here.
Correct.
And you thrusted it into this.
Just also a little bit remarkable to me that her attorney's actually demonstrating in this in court. I mean, you know, kind of normal trial practice is that if it's something violent that your client has committed, you probably don't want to place those images in the jurors' minds. I could understand the prosecution doing this. I can understand the prosecution asking her to actually demonstrate it. But it was kind of a remarkable thing to me that her attorney chose to be the one to demonstrate this way.
The areas of the suitcase?
I started with his hand and his hand, he was still trying to get out. He was still trying to do that. So I started to push on the suitcase around it, hoping to have his hand retract and go back inside.
You made those injuries.
I did,
We've seen the photographs.
yes,
We see the bruising. Is that from that bat?
yes.
Eventually, did his hand go back inside from you doing
Yes, finally he had subsided and retracted his hand.
So in your mind, did you prevent him from attacking you?
Absolutely. Split second decision.
Now, once he retracted his...
Okay, I'm going to cut in a little bit, and I'm going to make this point more than once, but as I was watching this, I realized something. There's two very different versions, theories, arguments as to what the actual crime is here. The defense is trying to make the crime that right there. That moment right there, I was afraid for my life. It was a split-second decision. I acted under under that fear. While I was still under the effects of that fear is when I acted, and how I acted is I hit his hand with the bat. I pushed it with the bat to stop him from getting out, to save my own life. That's kind of textbook self-defense, right? That I was under a reasonable apprehension of fear. I used a reasonable amount of force to defend myself. Problem is, as we're going to find out, that's not what really caused his death. No one is, she's not being charged with assault. The hitting his hand with the bat was part of the problem, but not the real problem. The real problem was leaving this man trapped inside of a suitcase to suffocate to death. But if the defense has their way, it's that moment is her act of self-defense. And the prosecution, if they're going to do their job properly, is going to say, well, that's part of it. But really, the act of murder was leaving a man trapped inside of a suitcase who's begging for their own life, telling you that they cannot breathe. That is the indifference. That is the malignant heart that you had that allowed this person to lose their life. So the defense, they're trying to split very fine hairs here, but that is what they want the jury to focus in on.
Do you remember zipping it up some? What did you do in relation? Because he was upside down, was he not? At that point.
Yes,
At some point, you flipped him back up.
I did.
Tell how that happened.
He wasn't cursing. He wasn't threatening. His hand was inside foremost. There was no more of him trying to break through the suitcase. So I felt safe enough to turn it back over. It wasn't happening anymore.
You went back to the video and the couch,
I did, yes.
and we saw the second video,
Yeah,
the 22-second, and he's right side up again,
yes,
and you hear him say, Sarah,
yes.
had you left enough room for him to get out? Zipper to zipper.
Yes, that's how his hand was trying.
That suitcase has two zippers, doesn't it? And they meet at various places along the line.
Correct.
How much room, when you flipped it over, how much room was between zipper to zipper?
Specifically, I mean, it was enough to where his hand was coming out.
Also, I think an important pivotal point for the defense is, okay, then I left him, but I left him with the belief that he could still get himself out of that suitcase after I, quote unquote, felt safe. You know, let's not miss, by the way, how we are running the gamut of emotions here within a matter of seconds. In 1 second, they're playing a game. She's taking a video where she's laughing at him because she's got a captive audience. The next moment, she's afraid for her life. And now she's totally calm to the point that she's, by the way, going to go to bed.
You hit him with the bat. Was he not trying to get out anymore? Did you believe that he could breathe in there?
Yeah.
That's important.
Did you ever believe he could die?
No. Oh,
Well, you tried to kill him.
no,
Did you want to kill him?
I did not.
Did you walk upstairs?
I did, yes.
Why didn't you let him out before you walked upstairs? Were you afraid?
Terrified is more of the word.
As long
Terrified, but you walk upstairs knowing that he can still get out. These are the discrepancies that are going to tear this house of cards down. And they're only discrepancies if you're having a very difficult time putting together a believable story.
he was in the suitcase, he couldn't harm him. Please. Did you want him to calm him?
Yes, I want him to stop being angry because I know what it is for him to be angry.
And I thought the best way to calm him down was to leave him suffocating inside of a suitcase.
Upstairs. Go to the dog.
The dogs ran upstairs with me.
And where did they go?
On the bed.
Did you have the phone with you?
Yes,
I know at some point you called your husband Brian, did you not?
I did.
Do you recall how long that conversation was?
Not very long.
Can you recall what was said?
I don't remember exactly. No, I don't.
This guy, Sarah, you said that when he was in the suitcase, he was threatening her, threatening you. Can you tell the jury what he was saying?
I don't know. Am I allowed to curse?
Yes.
But he was going to fucking end me. And that's what made me ask him please to stop doing what he's doing to me. That he was going to, I'm guessing, try his best that night to probably take my life.
But what? The threat you heard was
He's going to
say the word.
end me.
Excuse me?
Fucking end me.
And you?
Yeah.
Yes. Yes.
Okay. So I'll stop it there. Because say what you will about her testimony. And I think there were gaping holes in the logic of it that you could drive a truck through. But as far as the defense was concerned, I think this was a mission accomplished bit of testimony. Now, please understand what I'm saying by that is I'm not saying I find it convincing. I'm not saying that it even establishes self-defense, but it accomplished exactly what they needed it to accomplish, because bear in mind, she is testifying as witness number one, because their entire case rises or falls in these moments right here. She has to establish there was an overt act to allow for a self-defense argument and to establish the predicates or allow them to establish the predicates for a battered spouse syndrome defense. Every witness they want to call after this person is going to all depend on what took place in these few minutes of testimony that we watched right here. And that's why I wanted to watch this whole thing. Everything leading up to that was just kind of background about their lives together, the events leading up to the night. But it was what took place in those 11 minutes. Was it fear? Was there an act? Was there something he did? Was she acting under fear at that time? And then if all of that is true, and that rises to this very, very low threshold, she will be allowed to explain that, because part of explaining it includes a holistic understanding of her state of mind. And you cannot appreciate that, ladies and gentlemen of the jury, unless you understand the entire background, which includes their contention that she was suffering from battered spouse syndrome, which adds to the lens in which you view her reasonableness under these conditions. Okay, so if that is what she intended to accomplish and her attorney intended to accomplish, then it was mission accomplished. And I just saw Afton said he's leading the witnesses. He is absolutely leading. And I'll tell you, I think the prosecution was sitting on their hands as far as the objection goes, especially when it came to leading, because let's just get it out there. Let's get it done. I don't want to deal with suffering and slogging through the mud to get this testimony out there. Let's get it done so I can get to my cross and we can get to the real meat and potatoes of this case. Okay, so you heard the Owens just say, Judge, can we approach? Because he feels now that he is established enough for that overt act to allow the floodgates to come open for the defense. And let's get into, I want to watch the arguments that they make. Hold on. Oh God. Sorry, I'm going to try to get through this as quickly as I can.
Babe, I can't see it.
Okay, so he's dismissed the jury now, and now it's time for the arguments.
Proceed with any argument at this point in time. But I believe that's pretty close to what we already knew from the deposition testimony, from the doctors relaying what she said for the proper. What we have here is testimony from the defendant. Her timeline is she comes downstairs after having gone up to the shower and hiding, laying down, after being declared to be it. She comes back downstairs, and before she gets back to the bottom of the stairwell, she can see that the victim is in the suitcase trying to get flat because the lid is flopping and he's not hidden just yet. And so she comes over, and I believe she testified she was moving it around before actually zipping the lid shut, but moving it around, everybody's laughing. It's all fun and games still. And then she zips it, and it's still fun and games, and everybody's laughing. And then at this point, she testifies that this is now her opportunity to get on her pulpit to express her true feelings about everything. And that's when she sits down on the couch and opens up her phone device and begins recording what later turns out to be IMG _1062.movie at 11:12:45 for 2 minutes and 3 seconds. During this period of time, the decedent is expressing meekly that he can't breathe. The only time he ever curses at her is, Tara, I can't fucking breathe, babe, I can't fucking breathe. He is demonstrating under the law that he is in fear with his life. She has committed an aggravated assault. She has committed false imprisonment. She was the initial aggressor. There was no overt act to justify these actions that she took against her boyfriend. She then goes on to say that during this period of time between the end of the movie at 11:14:58 seconds and before the next one starts at 11:23, that it's now at this time, while he's still constrained and clearly unable to get out under his own power.
I just got to pause to admire this judge for a second. I think he's fantastic, but I also think it's amazing the poker face this man can wear, not taking a single note. He already knows where he's going on this whole thing, and he's incredibly patient to allow them to make their record, but just does not give you any inkling of what's going through his head at all.
Despite having his hand out, she begins beating him with a bat, poking his hands, poking the suitcase with a deadly weapon. A bat is used for baseball, but it can also be used to harm another person. And according to the medical examiner's testimony, there was great harm caused to him, deep ecchymosis bruises. She can't start to do this out of fear, like the analogy I gave earlier. If I pull a gun to rob you, Judge, and you pull a gun, I can't shoot you in self-defense. She started this. She started this. There is no overt act, and therefore.
So one good point that he's making there that I think is worth talking about is that there is an idea when it comes to self-defense that you cannot invite the conflict. In other words, you can't walk into a bar, spit in a guy's face, he starts to punch you, then you pull a gun on him and say, well, I was just defending yourself. You cannot invite the conflict. You cannot invite the situation, create the situation that then leads to you feeling that it's necessary for you to use deadly force. So he's saying, listen, she's the antagonist here. She's the one who's kept him inside of that suitcase. She's the one that's hitting him with the bat. She's the one that's shaking him around. She's the one that's taunting him. All of these are really good points. He's saying she cannot then take advantage of his response, which, by the way, is just a man inside of a suitcase saying, I'm going to kill you, if she's to be believed, and say that then that somehow gives her a reasonable footing to use deadly force against him, which in this case was leaving him there.
Asking for you to prevent, under the case law, any prior instances of violence, any reputation evidence, and any battered spouse syndrome evidence, because that's simply just what the case ended up being. Thank you. Response.
Judge, this was a game by two intoxicated people. When people are drunk and intoxicated, they do silly and stupid things. The evidence is uncontroverted that George Torres willingly, by his own choice, elected to hide in the suitcase. By their interaction between the two of them, giggling and laughing at each other, he consented to her zipping up the suitcase. And the playful nature of what was going on during those few minutes prior to the video. When the video is turned on, there's a 2-minute period where they're talking. He's saying, I need to get out. I can't breathe. She's not taking him seriously. As you've seen from the videos, I thought it was the boy crying wolf. She did not appreciate the fact that he could be actually having trouble breathing. And this was a chance for him to be heard by her about how she felt about some things involving their relationship. A short time later, the video was turned off, and then that period has been testified to by my client. And that period is uncontroverted. That's a second period of time. We've got that time for the video. We got the 11 minutes. We got the 22 seconds. And there's no video. There's no audio. There's no eyewitness. There's nothing but Sarah Boone's testimony. And she's testified here today that they had words. There were threats. He got his hand out of the suitcase. She knew by the threats and him getting his hand out of the suitcase that he was about to get out of the suitcase and he was going to hurt her. A reasonable person under that scenario would believe she was about to be harmed. She was an imminent threat of harm. She blocked that attack. by grabbing the bat, hitting his hand. When that didn't work, she started poking him with the bat in the suitcase. Eventually, she poked him several times. He put his hand inside the suitcase. She put the bat up. When she realized he was not going to do that any further, she flipped him over right side up. She still had a fear, knowing that if he got out, she would be harmed. He would beat her up. She went upstairs. That is an overt act based on the discussions, coupled with the fact that he threatened her, using the word, "I'm gonna fucking end it for you," or some words to that effect. I don't remember her exact words, just before she went upstairs while he was still in the suitcase. If she would have let him out, and this is a crime, now this is an event involving an omission, failure to act, failure to unzip him at that point, before she went upstairs. The failure to act, the failure to unzip, which would have let him out, which would have created a situation that she believed was imminent bodily harm to herself. And I guess I'll get a couple of examples. Let's say that a police officer is called to a scene, and the only thing he hears is there is a suspect, and the suspect may be armed. So, of course, the officer pulls out his revolver, and he's walking around, but then eventually he finds the suspect, and the suspect reaches for his waist. The officer doesn't see the gun, but the officer sees the movement to the waist. The officer fires and shoots the suspect. The officer is justified because there's an immediate threat of harm. The officer has to react instinctively. There's no time to think. Similar to the actions that Sarah Boone had to take. Another example, you're in a
Okay, that was a painfully awkward analogy there. I mean, he explained it perfectly. He explained perfectly how that would demonstrate self-defense, how in that instant, in a with all the surrounding circumstances indicating that there might be danger afoot, and the officers responding, and if somebody makes a furtive moment towards an area where a weapon might be, and they have to act in that moment. Sure, great. He did a great job of explaining that. The problem is how none of that fits into the factual scenario that was just presented by his client, because again, if it comes down to her quote unquote poking him with the bat, according to him, maybe, but that's not the crime here. The crime takes place over her leaving a man suffocating to death inside of a suitcase and abandoning him to fend for himself while she goes to sleep. That there is the problem, and there's where it's very different from the analogy that he just gave. You can excuse and understand the actions of the officer he just described in that scenario. You cannot excuse and understand the actions of a person who, in fear, leaves someone to suffocate to death and instead decides to go to sleep. If you take this case in its microcosm of what took place in the moment when she hit him with a bat, perhaps they have a puncher's chance. But this case is way beyond all of that. He was still alive when she was hitting him with the bat.
With your buddies, and you've had something to drink, and another group has had something to drink, and one of your buddies gets into an argument with one of the buddies on the other party. And one of your friends, seeing that it's being escalated, and the guy that's arguing with your buddy is aggressive, more aggressive than your buddy is. Your buddy's trying to settle the thing, but this other individual, maybe he's had too much to drink and he's more aggressive. So you go around behind this individual, and before he's able to strike your buddy, you grab him, you lock him up. That's physical restraint to block an attack. And you grab him by the neck, and you choke him. physical restraint to block an attack.
I think we're seeing more physical restraint out of the judge right now, that he's not just losing it to have to sit through this.
That's what she was doing with the suitcase. If she let him out of the suitcase, she was going to be harmed based on him trying to get out with his hand, based on the threats he made while he had his hand out, and based on the threats he made while he had his hand inside just before she went upstairs.
Thank you. Court's going to review all the case law that is obtained in its research in this matter, come back with a oral ruling momentarily. Thank you.
That is code word for I have already made up my minds long before you guys ever stood up to speak. And I'm going to give you my ruling in just a few minutes here. So neither one of those arguments, I mean, I hate to sound like one of these people who's, going to Monday morning quarterback this whole thing, but neither one of those arguments were entirely all that convincing. The defense's argument, he's just describing self-defense for the judge as if the judge doesn't know. And I think why he's doing that is he had to fill up some time, and he really doesn't have a way to explain how it fits into the facts of what his client just testified to. But, she's staring at him, so she's got to earn that dollar that he's not making. And the prosecution, I think that they were wise enough to know that this probably wasn't going in their favor to begin with. I wish that maybe perhaps they had explored that idea of inviting the situation a little bit more, but I'll tell you why perhaps the prosecution is not fighting as hard, and why the judge, I believe, has already made up his mind. But let's go ahead and get to his ruling first. So he then steps off the bench and comes back just over about 10 minutes later. Let me see if I can do this without having us all suffer through. Oh, come on.
All right, we're back on the record. State of Florida versus Sarah Boone, case number 2020 CF 2603. Appearances for the state.
Take cash for state, state.
Defense.
My name's Owens from the student.
County Henderson, Sarah Boone. Coming back on that sound.
Ms. Boone is currently seated at counsel's table, wearing the same clothing from this morning. The court has had the opportunity to review the case law, review the arguments provided by both the state and the defense. The court finds that a overt act has been established. Case law is clear that a scintilla of the providing of an overt act is sufficient to provide the self-defense jury instruction. An overt act is not something that's specifically defined in Florida case law. It's something that's from the totality of the circumstances, seemingly under the authorities that the court has reviewed. As such, the court is going to find that under Holland, a overt act has been established and will allow the defense to proceed with evidence of reputation and specific instances of conduct and that spouse evidence, so long as the necessary predicates are established for those items. Any questions or clarifications with regard to the court's order statement? Defense.
Okay. And that was quick. That was super quick, super direct to the point. All of the arguments have been made, and he wrapped it up very cleanly. And I know that's disappointing to a lot of people watching, but I'm going to explain why I think you shouldn't be too upset by it. But essentially what he's saying is an overt act is not defined. An overt act has to be determined by the surrounding circumstances. It has to be an act, obviously. It has to be something that you can point to, some action taken by the defendant. But as long as that evidence of that is, and I love this term used in the law sometimes, a scintilla of evidence, which essentially means a dusting of evidence. It's a very low standard. It's certainly not beyond a reasonable doubt. It's not even preponderance. It's just the idea that, you know what? There was some evidence there. Now, That does not mean, and I know a lot of people are saying, well, does that mean that anybody can get self-defense instruction and anybody can get a battered spouse syndrome defense if they just get up there and say, well, he did X. No one else witnessed it. I witnessed it. I said it happened. Therefore, I want this entire defense presented. No, this case is slightly different. First of all, I do not miss the irony that the single most important thing that took place that evening, according to Sarah Boone, happened to be in the 11 minutes that she didn't record. She had her phone out and happy to record her as she mocked him and he begged for his life. She put it away for 11 minutes. Apparently during that time, he threatened her life, but she didn't get out her phone. Then she turns it on for another 20 seconds when he's returned to a more docile state of begging for his life and her laughing at him. So in that 11 minutes worth of time, she's saying the entire basis to establish her self-defense took place. And people are saying, well, that sounds like a bunch of horse crap. And how can you allow that to happen? And couldn't that happen in any case? Why this case is different is for a couple of reasons. One, there is corroborating evidence in the sense of the injury to his hand. She's saying, I hit him with a bat. There was a bat present. There is an injury to his hand. But really, the driving force behind this and why the judge made the decision is the prior domestic violence. We know that that existed. There are police reports. Those cannot be ignored. There were times where George, was arrested and I think actually did jail time for domestic violence as it relates to Sarah Boone. This judge is simply not going to overlook that. That is corroborating evidence that what she is saying here may have taken place. But end of the day, this judge knows he doesn't have to just get this case to verdict. He's got to get it to a verdict that sticks. This is a incredibly litigious person. She is going to appeal this. If there's a conviction here, it will be appealed. And he wants to make sure that there's nothing that he does that causes there to be a problem with this conviction if that's where we end up. And so if that means that he allows her to put on this defense, so be it. Going through that path, extending this trial by a few more days, having to sit through these experts, having to hear her testimony about all the things that she suffered at the hands of this man is worth preserving that issue, or instead not creating that issue so that this verdict can stand up on appeal. I applaud it. It's a difficult position for the judge to be in. I don't think the judge really buys it. I don't think I think he buys that home was full of violence on both sides. I think that he thinks they were alcoholics and that they were violent toward each other and living, on the fringes of society. I don't think for a moment he buys that she was in fear of her life and didn't let him out of the suitcase, but he knows his job is not to make that call. His job is to make the call according to the law. And she did present a scintilla of evidence, and that evidence was corroborated by other things that he cannot ignore, other things that did not just simply come out of her mouth, things like police reports. So what he just said there is, I'm going to let you get into the reputation evidence, meaning the prior police reports, the prior conduct. And as long as these establish the predicates, then they're going to go ahead and allow experts to testify on battered spouse syndrome. So that's what we've been listening to. If you've been following the case for the last couple of days, is all of these experts telling us what should we do with this information and how should that change the lens in which we view this entire case. This was a big win for Boone. There's no denying that. This was their case rose or fell on this moment right here. They did what they needed to do. She testified the way that she needed to testify. The judge was likely going to rule this way anyways. It wasn't like they pulled off some amazing feat here. The judge was likely going to rule this way anyways, just based off of those police reports. If she came up there and said, I was afraid, they identified an act, his hand coming out of there. So it was kind of a no-brainer for the judge. All right. One last thing I wanted to show you on this was what I felt was the strongest point in the cross-examination, and it didn't really have to do all that much with the questioning. I don't know why this thing is giving me fits.
My exhibits.
Just bear with me, guys. Sorry. Okay. So now, this is her on cross, and she's being questioned by the prosecutor, obviously. And he's now asked her to step off the stand.
Can we see how it was with the two zipper parts were positioned when you say that Mr. Torres was able to get his hand up? If you want me to do it, I'm fine. I'll take your direction.
From what I remember.
See, this is the kind of stuff that is burned into jurors' heads. I'm so glad that he did this. I am so glad that he didn't simply bring the officer in to lay the foundation of how they recovered the suitcase, present the suitcase to the jurors, let them see it, put up a photograph of it, what have you. I love the fact that he brought it in there, placed it on the floor in front of those jurors, and had this woman actually manipulate and zip it so that they could picture in their minds the final moments of this man's life. That is incredibly powerful, powerful stuff. If ever given the opportunity to have a defendant testifying, when I was a prosecutor, to have them somehow demonstrate, recreate a moment of when the crime took place so that that is etched into those jurors' minds, that you cannot recreate that with any amount of clever questioning. This right here is worth so much. And the fact that he's asking her to manipulate it and show them how she zipped it up is phenomenal. So I don't know if he's faking this or what. She already had trouble zipping that. He's now struggling to zip it. I don't think he's faking this. But what are you thinking, folks, if you're the jurors and you're watching them have a difficult time zipping that thing up? You're probably thinking to yourself, what possibly could this man have done inside trying to zip it back open? It just makes you realize the death trap, literally, he was inside of as she abandoned him to go to bed.
It's not over there? Or do you?
You asked me where I zipped it.
When you say that it's zip shut, show us.
I'm talking about how I zipped it, or
When you're done zipping it shut, the pieces inside of it, where are the zipper?
Just to.
I mean, it's not. Yes, this one was on the movie. From what I can remember. That's how he was cutting with his hand out. It was like this from the corner.
Thank you.
I mean, just look at that thing as it sits there, and you have to, and the jurors, they're doing everything that we're doing right now. They're imagining how a human being can fit inside of that thing for 11 hours.
change the position of those zippers once you put it in that position? And so once he was zipped into there, there's some amount of time that you don't remember specifically before you start taking the 2-minute video, correct?
Yes.
And then that's when you say what you say, and that's when he says what he says. We've all heard it, correct? And then between there and that second video of the 22 seconds length, it's at this point where he's beginning to get angry. And then that's when you take the baseball bat that's in evidence, and your testimony is start poking at the end of it.
Did you say this was the second video?
Between the two videos, that's when you started hitting with the bat because he was getting angry and trying to escape, correct?
Right, it was not hitting him, it was, yes.
Okay. Did you ever hit him with the bat while he was outside the suitcase?
No.
So each time that he is hit with the bat, it's through this suitcase. And that's what leaves the mark on. You didn't hit him with the bat outside the suitcase, correct?
Yes, they haven't started.
No, it's okay. Suitcase will speak for itself. And then you take the second video and you go upstairs and go to bed, correct?
I apparently went upstairs and I used the phone to make a phone call.
Okay.
And then I fell asleep.
All right. And at the point in time when you left him on upstairs, he was still inside the suitcase, correct?
Correct.
Was he still asking for you and calling your name?
Not that I can recall.
Did you say shh to him again?
I don't remember.
Did you tell him that this was his problem and it's on you again?
I don't remember.
Did you do anything to help him escape from the predicament that you zipped him up in?
No.
No other questions.
I thought that was good. I thought that the way he ended that was good. I mean, it's just he highlighted the idea that this man's body is got other bruising on it. You didn't ever hit him outside of the bag. So you were doing more than just hitting his hand while he was trapped inside of that bag. And then you take this other video where he's simply begging for his life. And then you calmly go up to bed and you don't tell him that's the end. You don't tell him, anything else, and apparently your fears are over, and this homicidal maniac that is trapped inside of the bag is no longer a concern to you. I could go on and on about, just kind of, I think what he needed to do, and I think what he did was highlight the callousness of that moment. That is the crime to the prosecution. The crime isn't hitting him with the bat while he had his hand out. The crime is going to bed, knowing that that man is trapped inside. Now, she said on her direct, she was asked by her attorney, did you believe he was going to die? That's not really important. What is important is that she knew he was trapped inside of there. He tells her he can't get out. She's prevented him from getting out. You just saw the zippers. No one can get out of that thing. They can't even open it when they're on the outside of it. 3 people struggled to zip that thing. The murder took place when she casually went upstairs to bed. She left him to die as if he was a person drowning to death inside of a lake, and she's simply walking away with the life preserver. That is the act that creates the second-degree murder in this case. It's that indifference to his life. So let's hop into some questions. That took a lot longer than I thought. I hope that was interesting to you guys. I thought those were really the highlights from the testimony. All right. Jody says, what are your thoughts about the defense? Do you think they pulled ahead of the prosecution? I don't think so. I think because at the end of the day, I think they still have an incredibly awful case. I think that they've got an unsympathetic client. I mean, she's still, nothing about her testimony made her all that empathetic to the jurors. I didn't feel the fear. I didn't feel a person who had lost the life of someone that they cared about. That's a big part of what makes a person's testimony convincing. But what they did do is they turned an absolute loser of a case into a case where they might have a shot. They might have a shot to convince one of these jurors, because they've now opened up the floodgates when it comes to, presenting a defense. They've got their self-defense in. They've got their battered spouse syndrome in. So great question. What else do we got? Disney Nerd 85 says, wouldn't leaving him in there give her speech to him? Wouldn't leaving him in there to give her speech to him be considered false imprisonment or something to that nature? Absolutely. And that's what the prosecution again identified. He's saying she's already committing crimes here. She's committed an assault. She's committed a false imprisonment. You don't then get to turn around and say, because I committed all these crimes against this other person, they responded in a way that scared me so that I had to let them die. That's not the way it works. And by the way, he'll still make those arguments in his closing. It's just, as far as the judge was concerned, that didn't change his mind when it came to that scintilla of evidence for an overt act. But great question, Disney Nerd. Let's take a couple more, and then I did promise you guys some other entertaining stuff, and I'll get to that. Katie says, could you please discuss the difference between second-degree murder and manslaughter in terms of her charges? She's charged with second-degree murder. Manslaughter is considered a lesser included offense. So she's not really charged with that, but that will be an instruction that's given to the jury. And essentially, it's a degree of intent. In second-degree murder, you have an intent to kill, either through your actions, your indifference to what was taking place, your malignant heart, whatever it is. In manslaughter, it's mitigated, that intent, by either heat of passion, we've all heard of heat of passion, or a situation like this where you believed that you were honestly defending yourself, but perhaps that was unreasonable. You did not actually intend from your actions, even from a reasonable observer's perspective, that you intended to kill, but you were doing something in such a negligent way that it caused that person to lose their life. It really just comes down to intent. And if the jurors buy, she could still get manslaughter here, even with the self-defense. If they buy that she, because of battered spouse syndrome, was in some sort of reasonable apprehension, but acted unreasonably in response to that, or was not reasonable in her apprehension, but did act reasonably in her response by leaving him alone, whatever combination of those, as long as it doesn't rise to the level of a actual self-defense. If they find actual self-defense, they find that she was both reasonable in her apprehension, reasonable in her response, then you're talking about an absolute defense that could walk her out the door. Thank you, Katie. All right, Kaylin, what else do we got? Let's do one more. Afton says, would you have objected to this if you were defending Sarah, the suitcase demonstration? He can go ahead and object all day long. It's going to happen. I mean, this is evidence. He's allowed to ask her to demonstrate what they did. She testified to it. Here's the evidence. Go ahead and show us exactly what you did. And in fact, I probably would not have objected, because I think objecting to it draws attention to it and makes the jurors a little bit more curious as to why it is you don't want them to see that. They knew that that was a risk that was going to happen. So good on the prosecutor for doing that, because that is an image that will live with those jurors. The size of that suitcase, how difficult it is for that suitcase to zip up, the idea that she's beating a man with a baseball bat while he's trapped inside of that thing. And then I cannot get over, bringing her glass of Chardonnay casually to bed with her puppies in tow behind her, and then going to sleep as this man has been begging her for his life. I mean, that's a big part of this. He's not saying, Sarah, this isn't fun. Sarah, I'm tired. Sarah, I'm hot. Sarah, I'm missing the football game. He's saying, Sarah, I can't breathe. And that's caught on videotape. There's no denying that. All right. Should we get into quickly cover some of these other things I promised you guys we would do? let's get into Adelson because they, just to give you a quick background, what happened is oops, where did I put it? Hold on. Adelson asked for this kind of bizarre motion. Charlie Adelson. He's saying based upon what took place with Donna and her attorney, Rashbaum, that creates a problem for Rashbaum's representation of Charlie at the time that he represented him. And the argument was actually fairly good in saying Rashbaum chose not to call Donna. Hold on. I'm sorry, guys. Technical stuff. Rashbaum chose not to call Donna because doing so would have hurt Donna. So in order to protect Donna, he didn't call her, but in doing so, he hurt Charlie, if you guys can follow all of that. That I thought was a very clever and interesting argument. The prosecution has responded to that now. And I just want to show you the highlights of that really quickly, because it's not nearly as fascinating, I think, after the testimony that we've watched, but I think it's still worth talking about. So first of all, their first kind of question to the court is a question of kind of like, what are we doing here? Adelson's motion fails to explain what he would accomplish by having his case returned to the trial court, which is kind of a threshold issue. If you think about it, you got to explain what you're trying to accomplish by asking the court to do what you're doing. And just to be clear for you guys to understand, they weren't asking for a new trial. They weren't asking for a new case. They weren't asking for a conviction to be overturned. They were simply asking for it to be sent back to the trial court. So they're saying, what would be accomplished by doing that? 2, Adelson does not allege that a hearing is necessary to establish a claim cognizable in this direct appeal. So doesn't even say, even if you got what you're asking for, what it would accomplish. And then 3, Adelson's motion does not state that he's moving under any rule of criminal procedure. So you didn't even tell us what mechanism we can use to accomplish what you're trying to accomplish. And then finally, the only plausible claim that Adelson could make based on Rashbaum's conflict of interest is an ineffective assistance of counsel claim. And this procedure is best handled by post-conviction proceeding, meaning an appeal. So their first part of their argument is essentially, what are we doing here? What are we doing here? You haven't said why you want to do this. You haven't said what it will accomplish. And if you really want to accomplish what you're asking to accomplish, there's a better way of going about doing it. But then the other part of this argument that I wanted to highlight and I thought was interesting was what I call the you want to get nuts, let's get nuts argument. They then go on to actually touch upon this idea of whether or not Rashbaum didn't call Donna in an effort to favor Donna and, more importantly, harm Charlie. And this is where they get down to that. Thus, the record shows Rashbaum did not remove Donna Adelson from the witness list to protect her interests and thereby undermine Charlie Adelson's defense. In fact, Rashbaum had never intended on calling Donna as a witness. Instead, Rashbaum only listed Donna as a defense witness when he learned that the state was intending on interviewing her. Rashbaum believed the state was attempting to avoid discovery and gain insight into Charlie's defense. So, and finally, and even if Rashbaum had intended on calling Donna as a witness, there would only be a conflict if Donna Adelson's defense was detrimental to Charlie Adelson's case. There is no evidence of that. So, this just goes to show, I felt this was really well written, by the way, too. Just goes to show you, too, you can only trust these motions as far as you can throw them most of the time. If the people's motion is to be believed here, it doesn't sound like there's a whole bunch to the defense theory that Adelson, or Charlie Adelson, suffered actual harm from Rashbaum's representation of him and a prior representation of Donna. Kind of into the weeds, but is something I know that a lot of you guys are following very carefully and closely. All right. Our final treat for this evening, and I'll give you guys a little bit of a warning here. It's not as graphic as it sounds if you guys have not seen this already, but this was a demonstration done in the Courtney Clenny case. And her attorneys have asked for bail to be set. She has, since the time of her arrest, been in custody. And they are trying to find some reason to get her out of custody. And usually the way that you go about doing that is that you try to show some sort of change in circumstances from the time that the person was arrested till now. So in other words, you can't just keep coming back to the court and go, but we really, really want to be let out. You set no bail, but we're really asking you to reconsider because we really, really, really want to get let out. Usually it has to be some sort of change. You've done the preliminary hearing. They didn't get all of the counts held to answer. Now the case is a little bit different. It's not as strong as the prosecution thought it once was. Therefore, we're asking you to reduce bail. Some sort of change in circumstances can also include a demonstration to the judge that you have a very strong case as the defense. And because judges, it's important to understand, they don't know much about a case at all. When a case gets filed, they have the complaint in front of them. They don't have police reports or anything else. Sometimes they have some kind of short summary from probation or something like that, but mostly they're in the dark. So the most they're learning about all of this comes from the attorneys during different hearings. So sometimes you can use it as an opportunity to say, listen, Your Honor, they've charged my client with a really, really bad thing like murder, but we have an incredibly strong defense. And so therefore, we're not asking you to prejudge the facts here, but we're just saying it's probably a horrible idea to hold my client in for any much longer when my client has a very good shot at actually fighting this case. And therefore, please let my client out to at least defend herself. So that's essentially what they were trying to accomplish here. But I just thought this was great because the way they decided to do it is her defense is that she didn't stab her boyfriend with a knife. This is the case of the social media model, OnlyFans model, whatever you want to call her, who got into an argument with her boyfriend, allegedly stabbed him to death. She's now saying, I didn't actually stab him. I threw a knife at him from across the room, from about 10 feet away. I don't know how that changes things all that much, but they're saying that at least to support that position, that this is possible to cause those injuries, they asked to do this demonstration in court. And it was just something I've never seen done before and kind of comical. And also, I thought you guys might get tickled by the whole thing. But it does show a guy with a knife. Where are we at here? With a knife, throwing knives at a pig carcass. It doesn't get bloody. It doesn't get graphic, but you're all warned that that's what you're about to watch here. And it's not very long either. First of all, I have those knives. Those are global knives. They're really nice, just as an FYI.
Now, we're going to see there's no sound. Do you know if there was sound recorded or not? Can you describe to the court, I mean, you can see what's going on from your observation as an expert, examiner,
what, if anything, does this demonstration show you?
Well, you put 6 knives, and he's supposedly
I'm sorry. That's the whole thing. So that was my whole build up to show you guys this thing. I'm sorry. It's a little bit ridiculous, but I don't know. It's just one of those things where you never know what is going to take place in Courtroom. They put some money into this. They had to hire that guy. They had to hire the filming team. They had to pay for the pig carcass and everything else. Some expense went into this. And all just to show that, hey, by the way, a knife can injure someone if you throw it at them. That's the part that is most fantastic to me about this whole thing, is that as if there was an argument that throwing knives at someone is a safe undertaking. We want to disabuse you, Your Honor, of that misunderstanding. And in fact, throwing knives at someone can cause injuries consistent with leading to that person's death. Ashton asked, is it a throwing knife she used? No, it was not. It was a kitchen knife, but I think those were actually kitchen knives. I did recognize them. I think we have those as the type of knives, but it's just, I don't know. It was just kind of a ridiculous situation. But end of the day, the judge did not rule on this, which I found was surprising. But I think what the judge is going to say is, great argument. I can't wait to see it at trial, but it's not going to change anything. This has not changed circumstances. This is not going to do a whole bunch. Go ahead and present this at trial. If you can lay the basis for it, go ahead and see if you can't convince jurors this is what caused those injuries. But here's where we find ourselves. Anyhow, do you guys have questions on this? On the pig carcass getting knives thrown at it? I hope that was worth the extra minutes on your Wednesday evening. But again, thank you guys so much for being here. Kaylin, did we have any questions that I missed? I know sometimes I speed through stuff. I'm getting a look like, no, maybe not so much. What I like to do too is sometimes if I miss your guys' questions, I try to put a short video together during the week to answer some of those and revisit some of them if I can. But you guys have all been fantastic. Thank you so much for sticking with me tonight. Thank you so much again for taking the time on a Wednesday night to spend a little bit of it with me, talking about some of the more serious and some of the more ridiculous things that take place in the true crime world. A couple of quick housekeeping announcements. We did a video in our 5 Things You Need to Know series on Courtroom Confidential on the Menendez brothers. It is out now. I'm very proud of it. I feel like we did a lot of work. It is not like coverage of the Menendez brothers you may have seen before. It's not just about how horrible they were, or how horrible their father was, or how horrible the murder was. It's really about some of the legal issues attendant to this whole thing. And I think some of them are very fascinating. So please check it out. And then we are very excited that the following Monday, so this Monday coming up after this weekend, we are going to present the very first episode in our Courtroom Confidential Conversation series. And it is with Gisela K of Grizzly True Crime. We sat down, we had an interview. It was fantastic. We talked a lot about her background, where she came from, what got her into true crime and being a YouTuber. I know many of you are fans of hers. She's a big fan of us. I'm a big fan of hers. And we had a really, really enjoyable conversation. So please check that out. It will premiere next Monday, the 28th at 5 p.m. Pacific. Always really like having you guys in the chat if you're able to join us, because it's nice to kind of talk about these things and visit with you on a day that's not a Wednesday. In the meantime, you are all fantastic. I hope you have a wonderful evening. I am going to go upstairs and tuck some little ones into bed. Thank you guys again. And I will talk to you all soon. Take care, everybody.